All rise. Ladies and gentlemen, the Justices of the Supreme Court of the State of Connecticut. Open court, please. Yes, Your Honor. Oyez, oyez, oyez. The Honorable Supreme Court of the State of Connecticut is now open and in session in this place. All persons having cause or actions pending therein will give their attendance according to the law. Good morning, Your Honor.
Good morning. Good morning, everybody. The first case this morning is Wood v. Club, LLC. Is the appellant ready to proceed?
May it please the Court, my name is Jan Trindowski. I represent the appellant in this case. I would like to reserve 5 minutes for rebuttal.
All set.
As you're aware from the briefs, Your Honor, this case arises from an assault at a bar called the Thirsty Turtle in Stamford back in 2007. On that date, the plaintiff went to the Thirsty Turtle for a birthday party. The downstairs of the premises had been reserved for the birthday party for about 2 hours. After the 2 hours elapsed, the Thirsty Turtle allowed other patrons into the area. Pardon me. Some other patrons entered the downstairs, and eventually some of the patrons who were let downstairs tried to dance with some of the women from the birthday party group. The women found the dancing offensive, and I think at least one of the women complained to the bartender. The style of dancing was referred to as dancing up, and I frankly don't know what that means. I apologize.
Can you pull the mic a little closer?
Oh, certainly. I'm sorry. I tend to talk a little bit lower. The style of dancing was dancing up, and the way it was described is the gentlemen were gyrating their hips and waving their arms in the air and approaching the women. At some point during the dancing, the plaintiff, Patrick Wood, saw one of the gentlemen dancing over to his girlfriend or fiancée, and he decided he didn't like that idea, so he moved over and stood between them. At that point, the dancer struck Mr. Wood in the head with a bottle. A general fight ensued between the birthday party people and the other people who came downstairs. According to the testimony, the security, I think there were 6 security on premises at that time, broke up the melee. The assaulter ran out of the building. He was pursued by our general manager and ultimately identified to the police, but the police never arrested him. This suit followed. At the trial level, we tried the case before Judge Carras in Stamford, and the plaintiff presented an expert witness, Kevin DePalma. This appeal is limited to 2 issues, as you're aware. One issue being whether Mr. DePalma was qualified as an expert and should have testified in that case. The second issue being whether the court adequately instructed the jury as to the nature of negligence and the characteristics of liability for wrongful acts of third parties.
Mr. Trendowski,
certainly.
Regarding the claim on the expert, could I just refer you to page 14 of your brief?
Certainly. I'm there.
All right. If you go 8 lines from the bottom,
okay.
You rely on the appellate court case of Sullivan versus Metro North, where you say the appellate court dismissed an experienced and trained security expert for his lack of experience in railroad security.
Yes.
I'm sure it's an oversight because you cite the case later on for a different proposition, but we reversed that decision.
Yes.
On that precise point.
Yes.
We found that the expert was qualified.
Correct.
But that's not here in this part of your brief.
No, it's not. It's not.
And my question to you is, does the fact that we reversed it, does that change your analysis?
Oh, no, not at all. Not at all. What I was pointing out in that portion of the brief was that obviously we're dealing with an appellate decision here at this level. We're looking at what the appellate court did. The appellate court in this case allowed, let me back up. At the trial court level, the trial judge initially disqualified Mr. DePalma because Mr. DePalma testified he was not an expert, then decided to let him testify. The appellate court said that, indeed, Mr. DePalma was an expert. He was just being modest. So in the Sullivan case, what I was pointing out is that the appellate court has dismissed the testimony of experts who are far more qualified than Mr. De Palma. And the Supreme Court then reversed the appellate court, I don't know whether I'm using the proper terminology, stating that, in fact, I believe it was Kenish. Mr. Kenish was the expert in that case, in the Metro North case, stating that, in fact, Mr. Kenish had incredible credentials, was qualified to testify as to security. So that's the reason I cited it there, is that while the appellate court in this case holds a gentleman who worked part-time as a bar and denied that he was an expert, saying that he was a qualified expert, in another case, flipping it around completely, you have a gentleman like Mr. Kenish in the Metro case where he was incredibly qualified, and the appellate court said, well, no, he doesn't carry the proper qualifications. So, as a matter of fact, the two issues that we were talking about.
Well, wait a minute, Mr. Chandowski. I mean, I'm confused by that. If we said the appellate court was wrong, shouldn't you have told us that, as opposed to citing this as good law?
No, the reason I cited it is, obviously, we're dealing with the appellate court decision. You did reverse that case. The Supreme Court did reverse that case and hold that Mr. Kenish was, in fact, qualified. The reason that I put it here is that it's to contrast the fact that the appellate court, in the case we're here for now, had a gentleman whose sole qualification was working part-time as a bouncer and held that he was qualified, contrasted with a gentleman like Mr. Kenish, who I believe he had degrees in criminal justice, he worked as a police officer, he wrote on the topic. They considered him not to be an expert.
Okay, but just so we're clear, for future reference, if we have reversed a decision of the appellate court, you need to let us know that.
I believe I mentioned it later on, Your Honor. But, no question of it. No question of it. As a matter of fact, I was going to refer to that. On the first issue, whether Mr. De Palma was qualified as an expert, and I understand your concern, Your Honor, but I wasn't citing it to say that is the final word on the issue. Whether Mr. De Palma was qualified as an expert, what it leads to is the basic question as to what is an expert. And frankly, I've wrestled with that. Because the nature of expertise, you have experts in all different areas of technology, security, medicine. What common characteristics do experts have? What can we look for in an expert before we hang a badge on them and say, you're an expert in a case? Because the standard that the court used, does the person have any knowledge that the jury doesn't have, and is that knowledge helpful? I don't know that that qualifies them as an expert. Because if it's just knowledge that the jury doesn't have, for example, in Stanford, for years and years I worked as a mechanic at Sears Garage. And I know how to change tires. I know more about changing tires than the jury does. Does that make me an expert in changing tires? No, it doesn't. I'm simply a person who worked in changing tires. So in this instance where Mr. De Palma did not teach anybody, he had no training, he worked part-time, knew nothing about the national standards, what qualifies him as an expert?
Why can't experience qualify him as an expert? Haven't we said it can?
I'm sorry, Your Honor?
Haven't we said that experience can be a factor that the trial court can consider?
It's the quality of the experience, Your Honor, and I realize it's on a case-by-case basis, but when you look for an expert, I think that the qualifications for an expert should be a deeper knowledge of the subject matter. And as a matter of fact, the qualification, as mentioned by Judge Verdun in his dissent to the initial Metro North case, was that they should have a knowledge that's significantly greater, a superior knowledge, not simply happen to work in the field. Because in this case, to call Mr. De Palma an expert, he actually is a person who happened to work in the field and didn't like it. So when you add the qualification of a superior knowledge, what qualifies as a superior knowledge in the field? Not just that they happen to know something, but in fact a superior knowledge. Because once you put the badge on somebody saying that they're an expert, you're saying that their testimony, their opinions are above and beyond a lay witness. So in this instance, what you look for in an expert, I believe, is the surroundings for the expert. Do they teach? Do they write? Are they trained? Do they have some knowledge in the field which is above and beyond what somebody who just happens to work in the field does?
Counsel, if I had been a stamp collector and trader for 40 years and knew all about stamps and the value of stamps in the marketplace, and there was a case about the conversion of rare stamps, are you suggesting that there has to have been some kind of certification or licensure in order to qualify as an expert?
No, that can't be, because there are some fields where, in fact, there is no certification or licensure.
By the way, is there for security personnel for a nightclub?
There is, but it tends to be along the lines of, like, member of the Bar Association. There are associations you can join. There are some qualifications that you can get, but the nature of the qualifications tends to be generic.
Is there any educational program that you're suggesting that this expert should have participated in?
Oh, certainly. There is training for security guards. There are handbooks. There are, in fact, experts in the field who teach security, what to look for. Security, as a field, is, in fact, a field that both attracts and requires trained personnel.
And what experience did the defendant's expert have?
Good question. He worked part-time as a bouncer in a bar called The Playwright.
No, the question is your client's expert.
We didn't have an expert, Your Honor. As a matter of fact, when I deposed the plaintiff's expert and he stated that he was not an expert in the field, I was frankly somewhat surprised to see him at trial.
And is it your position that this case required absolutely expert testimony?
I feel that no, I actually don't. I think that the expert in this case, well, the difficulty is that the nature of the case, without the expert testimony, is a case for a directed verdict.
Is what?
A case that would have warranted a directed verdict for the defendant.
Why?
Why?
Yeah.
Certainly, Your Honor. What the expert did in this case, Mr. DePalma, is what he testified to was that he reviewed our security manual, and what the security manual stated was to look out for potential situations. And what he testified to after he was qualified as being an expert was that a potential situation, as I mentioned, dancing in this case, that dancing was a potential situation. And I asked him, a potential situation that leads to what? And the potential situation what it could lead to is anything, according to him, including sexual assault and murder. So what he did is he made the causal connection between dancing, which in and of itself is a non-criminal intentional act. As a matter of fact, some might consider it to be constitutionally protected.
Didn't your own witness the manager say that potential situations were situations that were known to result in violence and included male patrons making unwanted advances on female patrons, making them uncomfortable?
Yes.
So why would there have to be a directed verdict? You were on notice then that this was a potentially dangerous situation.
Although the appellate court rejected my point, that was all done after I had moved for a directed verdict. And in fact, the manager also testified that dancing was not a potential situation and testified to that several times.
Well, whether or not dancing is, didn't you begin this by explaining, it sure sounded like it to me, that what was going on, male patrons were making unwanted advances on female patrons, making them feel uncomfortable.
What I stated was, Your Honor, that they were dancing in a fashion that made the women feel uncomfortable. I don't believe they made any statements or any actual advances to the women. They were simply trying to dance with them.
That's a pretty thin line.
Are you drawing a distinction between the term dancing and dancing up?
Am I drawing a distinction between those two terms?
Yes.
No. Dancing is dancing in my book.
Okay, but didn't the manager testify that dancing up could lead to a potential situation?
No, I don't believe he did. I do recall him stating several times that dancing was not what he considered to be a potential situation. As a matter of fact,
wasn't there testimony that at least one of the women went over to a manager or someone at the security for the bar and indicated they were uncomfortable with the situation?
Yes, I mentioned that right off the bat, Your Honor. Yes.
And your manager said that an uncomfortable situation is something that can lead to potential danger, correct?
Well, that actually leads into the next question, or the next issue, Your Honor, is a question of scope. One of the issues, of the two issues that's in front of the court right now, is whether the court adequately instructed the jury as to the scope. Because what we're dealing with here, quite clearly, is liability for wrongful intentional acts of a third party. And under the restatement 442B, Section 442B, it holds that a person can be liable unless it's an intentional criminal act and not within the scope of the actor's negligent conduct. So question, what is the scope? And one of the issues in this case, as testified to by the expert in this case, is what is a potential situation? And a potential situation is defined as a situation that could lead to anything. The simple definition of it defies the word scope. There is no scope for the potential situation. If somebody's dancing badly, at least by the expert's definition, that could result in murder. It could result in sexual assault. Good thing he didn't have a gun. So the thing about the scope also, pardon me, this court recently decided Doe versus St. Francis Hospital, where there was an extensive discussion of liability for wrongful acts of a third party, i.e. Dr. Reardon. And in that case, this court discussed Section 302B of the restatement, which talks about the types of criteria that a court uses, or not the court uses, excuse me, as suggested by the restatement to look at what's within the scope of the negligent act. And the negligent act in this case was a failure to respond to bad dancing. That's simple. There is no other indicator or history or in the failure to respond to bad dancing, did you say? Bad dancing.
But you're not getting to the point of the women there being uncomfortable. You seem to be
uncomfortable as a result of bad dancing.
But the point is they were uncomfortable and they told the security they were uncomfortable, and then it just continued. No one went over to diffuse the situation, did they?
Well, the question is, I understand, Your Honor, and that's absolutely true.
And your manager said that, you know, a situation where women are uncomfortable is something that has to be addressed.
Well, what we're looking at in this case is whether in an instance where women are uncomfortable because of dancing is the precursor to an assault with a bottle on somebody who is not dancing. Is that enough of an indicator or something that would put somebody on notice that an assault is going to occur later on somebody who is not dancing? And what we're looking at is a non-criminal act, a situation where, let's say the women are correct, that they were uncomfortable. Is that a precursor to an assault with a bottle on somebody who's not dancing? And my position on that is no, it absolutely is not. Because if you are using the standard as testified to by the expert, that any potential situation can lead to anything else, then what is the scope of a potential situation? There is no scope on a potential situation. It can lead to anything. And I think the confusion arises as far as the standards insofar as liability for the wrongful acts of third parties is because even in the Doe versus St. Francis case, the court has not abandoned, as best as I can see, the concept that an intentional act can be a superseding cause. What the court discussed, and obviously it's my interpretation of reading the footnotes, is that it is negligence, that the actions of the defendant in the case are negligence. However, the proof is somewhat different. And
is it your position that the court's charge here didn't cover that situation? Doesn't the court go into the fact that there's some other cause that so minimizes the negligence that you have to find in favor of the defendant?
That is my position, and obviously I'll explain why.
But you didn't really request a charge on that, did you?
I absolutely did, Your Honor.
You requested a charge on premises liability under Stewart.
Yes.
Is that right?
Well, it's labeled liability for wrongful acts of third parties, correct, directly off the website.
And the court distinguished Stewart by saying Stewart involved a trespasser, whereas we have two business invitees here.
Yeah, and that distinction does not exist anywhere else. And somehow the court decided that an assault by a business invitee is somehow different in kind and quality than an assault by a trespasser. While the court made the distinction, I don't know where that distinction came from. An assault is an assault. So the status of the assaulter, I don't see any legal basis for a distinction as to, well, if the person's an invitee, we're going to treat this one way, and if they're a trespasser, we're going to treat it another way.
But in terms of the charge itself, what the court gave in terms of legal cause and proximate cause, you did not take an exception to.
Well, I had my charge that I requested and which was rejected.
On Stewart.
Yes, and so the court went on, and the court stated that it was going to give a charge on proximate cause, that it considered it to be a premises case, and that my objection was noted. So while I didn't get into chapter and verse as to why proximate cause would be inapplicable, indeed I did object, and then the objection was noted.
Can I ask you, in your brief, the argument seemed to change a little bit, and you were arguing superseding cause. You never asked for that charge, did you, with the trial court?
No, I did not. And I didn't because the standard charge on liability for wrongful acts of third parties includes a statement at the end stating that the charge on superseding cause should be given along with this. So the charge that I submitted requested it, but didn't specifically lay out the language of a charge on superseding clause. In the Doe versus St. Francis case, though, and I also mentioned the Perez versus Comba case, which was decided by the appellate court. And in the Perez case, there were a series of fights that took place and somebody was ultimately stabbed. And the instruction given by the court was that the jury had to find that the defendant was on notice that somebody was carrying a knife and going to use it. And the appellate court said that the harm only needs to be general, just related to the bad act, not specifically that you had to have a knife. And I noted that in the Doe versus St. Francis case, they were asking for a charge that the hospital either knew or should have known of Dr. Reardon's propensity to commit criminal acts, which was also rejected. And I think what the confusion is that because the court retains the idea of an intentional criminal act as being a superseding cause, the question is, what is the scope? And the court pointed out that the standard of proof is exactly the same for negligence. It's just a different type of proof. And unlike the Doe versus St. Francis case, I did request a charge encompassing the Stewart versus Federated Department Stores case. And also, I did challenge the evidence in the Doe versus St. Francis case. The defense did not challenge the evidence that was submitted, where in fact I did, and pointed out both during trial and in my motion for directed verdict that the act of dancing, the non-criminal act of dancing, is not causally related to, or the assault with a bottle is not within the scope of dancing, and that dancing would not be a precursor to a criminal assault.
I just want to go back
Certainly,
to the testimony of your manager.
Yes, Your Honor.
On the issue of dancing. He's first asked, he gives an answer that dancing is not a potential situation. That's what you've argued here.
Yes, Your Honor.
But then he goes on, and the question is, But if that male patron is making a female patron feel uncomfortable, that is a potential situation, correct? Correct. Question. And that's a potential situation because, one, that female patron, she could be assaulted. Isn't that correct? Answer. Anything could happen. Question. Sure. And one of those things, like you testified before, potential situations can escalate and they can result in violence. Correct? Answer. Correct. Question. Okay. And if one of those female patrons, if they have a male patron that's involved in their party, you don't want there to be a fight between these unwanted persons making these unwanted advances and that the male in their party. Correct? Answer. Correct. Why, in view of his answers, why doesn't that take care of any type of foreseeability issue, as you seem to suggest Stewart goes through?
I think because the operative word there is can. Could this possibly happen? Could this possibly happen? And going back to the concept of scope, is the assault within the scope of dancing? And if you have a situation where anything could happen, how is that foretelling what does happen? So what you have is a situation where if you miss anything, you're responsible for everything, no matter what it is. So if you miss the bad dancing and you don't do something about the bad dancing, you're responsible for any type of act that follows. And that is not scope.
But your manager seemed to indicate, he knew that violence could result from this.
He also stated that dancing was not a potential situation.
Thank you.
Well, he did say unwanted advances were, did he not?
Unwanted advances, yes.
Counsel, before you sit down, I just have a quick question. As far as the charge issue, the instruction issue is concerned on Stewart, it seems to me that, at least at this point, that the charge you requested is an accurate statement of the law. But when you look at what the charge that the court actually gave, the last sentence of the court's charge that's set forth at page 781 of the appellate court opinion, which talks about harm of the same general nature. Why doesn't that effectively deal with the issue that you were seeking to deal with in seeking the charge under in requesting the charge under Stewart?
Because in this particular situation, we're dealing with a superseding cause, the intentional act of a third party. In the Doe versus St. Francis case, the court pointed out that under the restatement section 302B that there's criteria that should be looked at, that this might have assisted the jury in resolving this question. The simple statement of the same general nature, that is not scope. It is very generic, whereas the restatement...
You didn't further define scope as it's defined under 302B. And so we discussed in Doe. Maybe you did, but it's not, if you did, it's not in
No, it's not.
So, the jury was going to have to determine, well, what does scope of the risk mean? How is that any more clear to a jury than harm of the same general nature?
Because the instruction that I gave, which was the law at the time, under the Stewart versus Federated Department Stores case, mentioned that there had to be a history, there had to be other factors, there were other things to be looked at, and those the court rejected. The court simply made the statement of the same general kind, whereas Stewart versus Federated Department Stores, which was the law at the time, required more criteria, that there be a history, that there be something for the defendant to look at and say, okay, this is a situation which could turn into harm.
Was previous conduct like this at issue in the case?
No. In this case, there was
You're suggesting that under law prior to Doe that there needed to be that history? Is that I don't understand.
Yes,
that.
well, because I certainly don't mean to go over, but in the Stewart versus Federated Department Stores case, there was a history of assaults in the parking garage. There were a number of factors there. They had it analyzed by a security expert who said they had a problem there. Half the lights were out on and on. Employees were being assaulted. So they had a history, and they had a situation where they had an area of their premises where they said, we got a problem here. We should be doing something about this. Now, in our case, on the flip side...
That was in part the notice.
Yes, exactly. And what we're looking at is how to predict an intentional criminal act? What do we look for to predict?
Okay, that's good. I don't want to take any more of your time.
That's fine. Thank you. Good morning, Your Honors.
Morning.
Please, the Court. My name is Frank Bartlett. I represent the plaintiff, appellee Patrick Wood, in this matter. I think Justice McDonald hit the nail on the head here when he asked Attorney Trendowski, do you draw a distinction between dancing and dancing up? And Attorney Trendowski's response was no. The defendants in this case, they didn't draw a distinction between dancing and dancing up, whereas all the evidence that was presented did. The defendant's bar manager testified, yes, he testified dancing is not a potential situation. But what he also testified is that what had occurred this night, preceding this event, male patrons making unwanted advances on female patrons, making those female patrons feel uncomfortable, that is a potential situation. That, Your Honors, is not dancing. That's what was referred to at the trial court as dancing up.
What was referred to as grinding, was it not?
Yes, grinding, dancing up. It was a situation where these male patrons were making female patrons feel uncomfortable. And that's the crux of what makes this a potential situation. You have these male patrons that are making unwanted advances, making female patrons feel uncomfortable. Mr. De Palma testified that that's a potential situation, and he didn't say that that's a potential situation that could result in anything. When you look at his testimony, specifically at page 148 of the transcript of July 30th, he says that that's a potential situation that could result in two things. It could result in a sexual assault on that female patron, or if that female patron is with other male patrons, it could result in a fight. That's the scope of the risk that was identified by Mr. De Palma. And that was substantially reiterated by Mr. Bemke, the defendant's bar manager. Now, Mr. Bemke said, he was asked, is this a potential situation? And he said yes. And as you had indicated, I asked him, and that's a potential situation because that can result in an assault. He confirmed that. And I said, and it's also a potential situation because it's known to result in violence. He further confirmed that. There was no dispute in this case as to the scope of risk that was created by the defendant's failure to intervene when these male patrons were making unwanted advances on female patrons. Now, I'd like to address the first issue for which the court granted certification, and that's whether or not Mr. De Palma was qualified to testify. Now, in the state of Connecticut, the court serves as a gatekeeper when dealing with expert witnesses. The court is they should analyze, it's a three-part test, whether or not that expert has special skill or knowledge directly applicable to the matter and issue. And I don't think that there's any dispute here that Mr. De Palma, who was worked as the assistant manager of security at the Playwright, a similar bar, for 3.5 to 4 years, that he had knowledge that was directly applicable to the matter at issue here, which was bar security. The next question is whether or not that skill or knowledge is not common to the average person. The defendants have conceded that in their brief. They've said the appellate court's determination that his knowledge is not common to the average person, that's likely correct. Third question that you have to ask is, would the testimony be helpful to the jury? There's no dispute in this case that his testimony was helpful to the jury. So the court performs that gatekeeping function. Does it satisfy that three criteria? In this case, Mr. De Palma satisfied those three criteria, and he was allowed to testify.
Counsel, at trial, did the defense, in cross-examination of the expert, call into question his qualifications?
They did call into question his qualifications. Now, the defense has argued on multiple occasions that Mr. De Palma testified he's not an expert. That wasn't the case, Your Honors. What he testified is that he's not a professional expert. He's not somebody who does this for a living. He doesn't testify as an expert for a living. He doesn't go around teaching classes. He doesn't give seminars. That was his testimony not only at the trial court, but in his deposition, which was taken just a week before trial.
Well, I just want to make sure that there was some voir dire was outside of the presence of the jury, presumably.
There was voir dire that was outside the presence of the jury.
But when he did testify, there was a cross-examination calling into question by the defense his qualifications about not having any training or anything like that.
Yes. When the jury was brought back in, the defense highlighted the fact that he didn't have these qualifications. And then when they were arguing to the jury, the defense again, they argued to the jury, he doesn't have these qualifications. And the court specifically instructed the jury, when it provided the charge, that it was the jury that was to examine his qualifications, to determine what weight the jury was going to be giving to his testimony based on not only his qualifications, based on his skill, his knowledge, his training and experience, and the reasonableness and the rational basis of his opinions. So by giving the jury that instruction, the court, one, fulfilled its gatekeeping function in determining that this testimony would be helpful to the jury, and two, provided the jury with guidance as to how they were to evaluate this testimony. Now, proceeding to
was the defendant's manual marked as a full exhibit?
It was marked as a full exhibit, Your Honor. When the defendant's manual was marked as a full exhibit, that set forth the standard of care, which was not in dispute. Mr. DePalma testified that was an appropriate standard of care. Mr. Bemke confirmed that that was, in fact, the standard of care that the bar held themselves up to.
What specific language in the manual are you relying on for that?
The language in the manual that stated that the bar has a duty to constantly survey the bar for potential situations, and further, the language that said that the bar security has a responsibility to diffuse escalating situations. And again, there was no dispute that what had occurred prior to this incident was not only a potential situation, but the fact that it had occurred for over 2 to 3 hours before this actual assault had occurred, that raised it from a potential situation to an escalating situation. Again, that was testified to by Mr. DePalma and reiterated by Mr. Bemke.
And did Mr. DePalma essentially agree with the language in the manual?
He did. He stated that the language that was in the manual was the appropriate standard of care for bar security in this area. Now, the defendants have argued that Mr. DePalma, he didn't have knowledge of national standards, and the knowledge of national standards is irrelevant. In the Baranowski decision, which is cited by the defendants in their briefs, the court actually upheld a trial court's exclusion of an expert who had knowledge of national standards but didn't have knowledge of local standards. In this case, Mr. DePalma had knowledge of the local standards, which is the applicable law, but he didn't have knowledge of national standards.
Was there any testimony about how that manual was developed by the defendant?
There was no testimony about how the manual was developed by the defendant. And I think that what Your Honor is getting to is the issue of whether or not that manual was developed in response to prior situations. And that wasn't something that was presented in the trial court. If we were to move...
You're not suggesting that the manual itself is the standard of care. Whatever is in that manual creates the standard of care.
No, not that...
You're just saying that manual reflected the correct standard of care.
That's correct, Your Honor. Not that manual was the standard of care, but that was evidence of the standard of care, and that it was confirmed that it was the standard of care by both Mr. DePalma and Mr. Bemke.
Well, how is it evidence of the standard of care? What if the manual had a almost non-existent standard of care contained in it? You wouldn't be arguing that would be the standard of care or evidence of the standard of care, would you?
It would be evidence as to the defendant's belief as to the standard of care, but again, Mr. DePalma and Mr. Bemke both confirmed that it was the appropriate standard of care in this case. Now, moving to the issue of the jury instruction. Getting back to, if I may, getting back to the issue of whether or not dancing was the issue that created this notice of a potential situation. In my summation at the trial court, at page 16 of the August 4th transcript, I specifically told the jury that it was not the plaintiff's claim that dancing was a potential situation for which the bar should be held liable. But I further clarified to the jury that what we had here was not dancing. The evidence was not that this was just dancing. That the evidence was that this was more than dancing. Again, it was unwanted advances making female patrons feel uncomfortable. So the defendant's argument...
Just out of curiosity, once you had the bartender's testimony about unwanted advances, you didn't need an expert, did you?
That's correct, Your Honor. Now, moving to the issue of the jury instruction, the only jury instruction, or the only issue that was preserved by the defendants in this case, is the instruction on duty to protect from harm from third parties. As Your Honors had pointed out, the defendants neither pled nor requested an instruction on superseding intervening cause. In the present case, we have the reason why the trial court determined that the instruction was inappropriate is he drew a factual distinction between what we had in our case, where we have two business invitees at the bar, and what we had in the Stewart case.
But is the instruction that was requested, I know it's predicated on Stewart, why is that wrong?
Your Honor, I think that it's wrong because it's not the theory that was advanced. I think that the law contained within it is accurate, but it's not applicable to the case that was presented.
In what respect?
It was not applicable to the case that was presented because in the case that we presented, the issue of foreseeability, which is what that charge addresses, the issue of foreseeability was presented by the bar's actual knowledge that these potential situations which were occurring at the bar would result in violence. In Stewart, you don't have knowledge that a certain situation would result in a criminal act. In Stewart, what you have is there's an alternate way that you can prove foreseeability, which is by showing, hey, even if the defendant, that property owner, doesn't know that this particular situation will lead to violence, if they've had prior instances on their premises, then that can be used as evidence that harm of the same general nature of what had occurred in the past is reasonably foreseeable. It's within that scope of risk. So what we have here...
What did they have notice of here? They didn't have notice that... I mean, maybe they did, but they didn't have notice that this kind of dancing up would lead to violence.
That's the exact notice that they testified they had. They said they knew that this was a situation that leads to violence. And that's what...
When you say they said that,
Mr. Bemke, he testified that yes, this is a potential situation. The reason why we know this is a potential situation is because we know that it can lead to violence. The defendants admitted that at trial, and that's what separates this case from Stewart, is that in this case, we've got a situation where there's an occurrence that's going on at this bar. And the bar knows that if they don't deal with this situation, violence is going to result. All right? In Stewart, there wasn't a claim that the property owner knew that this individual was in their garage and was going to attack the plaintiff in that case.
So you're basically saying, and this goes back to your first point, that the testimony of your expert and the testimony of the defense expert were essentially identical.
Yes. And they were identical on a couple of issues. First, the standard of care, and secondly, that this was foreseeable. There was no dispute in this case that an assault was a foreseeable consequence of the bar security failing to act. And that's why the Stewart charge was inapplicable, because, again, this was foreseeable. And that's why even if they had requested superseding intervening cause, it again would not have been applicable because superseding intervening cause is only applicable to unforeseeable intentional acts. I know the defendant argues in their brief that superseding cause says that if there's an intentional act, that absolves the defendants of liability. That's not the law. It's only if there's an unforeseeable intentional act that it would absolve the defendants of liability. And in the present case, there was no evidence that was presented that what occurred that night was unforeseeable. So to present the jury with a charge on...
Are you saying that the defendant actually essentially conceded that this was foreseeable by virtue of the testimony of its expert or other witnesses? I mean, if that's the case, then what are we doing here?
I agree, Your Honor.
That may be your question as well.
It is, Your Honor. But the evidence, the defendants, they didn't concede it because the defendants still argued that it was unforeseeable. But the evidence foreclosed that possibility is what I'm saying. Based on all the evidence that was presented at the trial, no reasonable juror could have found that this was not a foreseeable consequence.
And based on the defense testimony as well?
Yes, based on both the plaintiff's testimony and the defense testimony. And further, the court instructed the jury on foreseeability. The court provided an instruction at the end of its proximate cause instruction on foreseeability. And it told the jury that in order for the jury to find liability against the defendants, the plaintiff had to show that what had occurred was of the same general nature of the scope of the risk created by the defendants failing to act, based on what the defendants knew or should have known. So even if the charge was to be given, the charge on that same law, although in albeit different language, was provided to the jury, and it did give the jury guidance on the issue of foreseeability. So the one charge that was requested, which again was a charge on foreseeability, the specific language requested by the defendant was inappropriate, and the court provided the jury with an alternative charge, which was also a fair and accurate statement of the law, and provided the jury with appropriate guidance on how they could determine the issues that were before it. So again, as far as Mr. DePalma's testimony, there clearly has not been an abuse of discretion by the trial court in admitting the testimony of someone who worked for 3.5 to 4 years as an assistant manager in security to testify about an issue that was not in dispute. As far as the instruction that's argued by the defense at the Supreme Court, superseding intervening cause, was not presented to the trial court, and therefore the claim was not properly preserved. And the one instruction that was presented to the trial court and was arguably preserved, one, has not been briefed by the defense, and secondly, the sum of that charge was given to the jury in different language, and therefore there is no error. Unless Your Honors have any more questions, I'll rest on my brief.
Thank you.
Thank you.
Just addressing a couple of points that Attorney Bartlett raised. One, the main issue here was foreseeability, and while as a threshold matter, as I mentioned before, I moved for a directed verdict, and then Mr. Bumke testified. Mr. Bumke testified that dancing was not a notice of an ultimate assault, although unwanted advances to women, in fact, were, and that's common sense. The appellate
couldn't the jury reasonably conclude, though, that this kind of dancing is, and I'm no more familiar with it than you are, it probably won't come as a shock to you to hear that, but isn't this sufficiently provocative that it could be seen to be, somewhat threatening or disturbing to people who don't know women who don't know the men who are insisting upon dancing with them in this way? Is that something that, seems sort of beyond common sense?
Well, what you're talking about is a situation where there's no contact and somebody literally is dancing, and how that escalates into an intentional criminal act on somebody who's not dancing.
That's a different matter. That's a different matter. The question is whether what I asked you is there doesn't this seem that this could be a provocative activity beyond, you're suggesting that dancing, is ballroom dancing or
not quite.
That dates me even beyond. But I mean, this kind of dancing is provocative. It's provocative, and it's provocative by its nature. You don't have to know much about this, it seems to me, to understand that that's what it is, and it's probably intentionally so. So, I mean, to say that it's either dancing or it's something else, it just doesn't seem to me that distinction is really a fair one. It's dancing, but it's very provocative, and it's potentially, disturbing.
But the question is whether you then make the leap to a criminal assault.
Well, that's a different question, though. That's the foreseeability question. But you're arguing that because it's dancing, this wasn't foreseeable. The question is, given the nature of this activity, is it foreseeable?
Assume you're correct. That there is a type of dancing, non-contact dancing, that's provocative.
Let me ask you this. Let's just say that there's a type of dancing where a group of guys circle a woman and dance around her in a provocative way. I mean, is that going to be? Yeah, that's a type of dancing. Isn't that provocative?
Obviously, that's not what happened here. This is one guy, but
it's worse what happened here. They were grinding. That's how it was described.
They were wagging their hips, Your Honor. There was no contact. So, I mean, going back to the day, I mean, they used to cut off Elvis Presley below the waist because he was grinding his hips. I mean, let's assume that there is dancing that is provocative. Assume there is
someone you don't know.
Assume there is dancing that is incredibly provocative, and I assume it's out there somewhere. What do we do now?
And the girls complain.
I'm sorry, Your Honor?
And the girls complain because they're uncomfortable, because they're unwanted advances. What do you do with that? Your defense witness said unwanted advances, that can result in violence.
That's correct.
Well, then, why isn't that the end of the case?
It's not the end of the case, Your Honor, because the operative word there is could. Is this notice of an intentional act? Does the criminal act fall within the parameters of the dancing?
Well, Counselor, as you go, I don't, and maybe you raised this claim in your cert petition and we didn't accept it as a question, but we don't have before us whether the evidence in this case was sufficient to establish a causal relationship between the assault and the dancing.
I'm sorry? I did raise that in my brief, Your Honor.
We don't have that before us. That issue is not before us. So the question is whether the charge was sufficient or whether the expert was qualified to testify. So your argument that somehow there's not enough evidence to establish a causal relationship is not an issue before us.
No, what I'm stating is that the instruction given by the court stating that this was within the general scope or the general nature of dancing, what I'm saying is that instruction is insufficient to make the connection here.
Within the general nature of dancing.
Exactly.
Okay.
Thank you.
Thank you. We're going to take a recess.
Thank you.